Pleasure to be here this afternoon. I thank Professor McLaughlin for inviting me to moderate this panel. My name is Lincoln Davies, and I'm a law professor here at the University of Utah Law School. It's my pleasure to introduce a very esteemed panel. In fact, I could probably spend half the time talking about the accomplishments of the members of this panel, so I'll try to be brief. First, we have King Burnett, who holds law degrees from the University of Virginia Law School and NYU. Was a Fulbright scholar at the Sorbonne in Paris, and has spent 40 plus years as a partner in the firm of Webb Burnett. He's also been a member of the Board of Trustees of the Maryland Environmental Trust, and is an elected member of the Maryland Bar Foundation, the American Law Institute, the American Bar Foundation, and the American College of Trial Lawyers.
Good afternoon. Talking about the Uniform Conservation Easement Act, and I thought I would just start with a couple of words about the organization that wrote it. The Uniform Law Commission was launched well over 100 years ago by a group of states and the American Bar Association. It includes, the members include every state in the United States, plus the District of Columbia and the Virgin Islands. Each state decides how its members are appointed. They all have to be lawyers. Most of the members are appointed by the governors of the particular state, although some states appoint commissioners from the legislature or from the judiciary. It includes legislators, professors, judges, and practicing lawyers. The Uniform Law Conference operates through drafting committees in the first instance. In the case of the Uniform Conservation Easement Act, the committee was in existence for almost 3 years. It would meet for 2.5 days at a time and go over every word of the statute together with experts in the field. We had tax lawyers, real estate lawyers, and lawyers involved in conservation easements themselves. I had just become a member of the Uniform Law Conference at the time this project was taken up, and I had already helped write a similar statute for the state of Maryland and was on the board of the Maryland Environmental Trust, which is a land trust, a state land trust. It's actually supported by the state itself. Its board is self-perpetuating, which is why I've been on it, I guess, for 40 years. And I've been appointed by Maryland's both Democratic and Republican governors to be on the Uniform Law Conference. The Uniform Law Conference has adopted lots of different laws in many different areas. Uniform Commercial Code, Uniform Probate Code, Uniform Trust Code, collection of child support across state lines, the Uniform Family Support Act, Prenuptial Agreement Act, definition of death. So it's a very broad Uniform Condominium Act, so there are many laws in the real estate area and the trust area. Now the Uniform Conservation Easement Act, it's amazing, it only has 5 sections. How could something like that take 2 years to write? It is amazing to write something that's terse and limited. It's a very limited statute. Most legislatures can't afford to take the time to really consider acts in this kind of depth. It has been adopted pretty much across the country. Some states like Virginia and Maryland and Massachusetts, and I think another state in New England, had adopted statutes before the Uniform Conservation Easement Act. And of course they served as models for the committee, the drafting committee, in doing this. We had 2 expert reporters, one who was active in land trust, representing land trusts, one who was active in teaching real estate law. The 5 sections are pretty simple, and the design is pretty simple. The idea was we have to be able to create a legal rule that will permit these easements to be established in perpetuity. That was the goal. And one of the 5 sections does that. At common law, coming to us from England, to have an easement, it had to be in an easement that was benefiting the property next door that would use the easement. But these easements, these conservation easements, don't have anybody owning the property next door. You've got an organization that doesn't own any property, probably. It may own a piece. It might possibly own a piece, but it would be a very unusual situation for it to own the property next door and therefore have a direct benefit for the property that they own. So this concept of having an easement in perpetuity was foreign to the rules that came to us from England as a matter of public policy. The English felt it was not good to have such permission, to have such restrictions on property go on forever. So the first problem was to make sure that we could do that, because it was clear that for like any other gift, it would have to be in perpetuity. You can't take it back. You know, we have rules that say that if you give a piece of art to a museum, you can't hang it on your wall at home. So we have a problem here with conservation easements, and it's very important to be able to create them. So the idea of first problem is what exceptions do we make to this old English rule, and how do we define what a conservation easement is, and how do we define what a holder is? So the first section of the Act defines a holder as being either the government or government agency, or a charitable organization. What a conservation easement is, it follows the definition I think that almost everybody would think is the case. It has to have a conservation purpose, so sort of it's in line with the rules of the Internal Revenue Service have put now in detail, which were then not really in existence, to either be in furtherance of, natural resource values or historic values. Now, who can bring judicial actions is the subject of another section. Obviously, the holder, and the Act creates a third-party enforcement. In other words, you can create an easement with a third party having enforcement power that is not a holder, which was a unique kind of concept that a number of states have adopted rules, and you don't see those too often, but it permits a holder or an enforcer who's not a holder. Then it terminates by saying anyone else who's authorized by law to enforce things, and that would be two categories of potential categories. One is the Attorney General, who by law, common law, or by statute generally has enforcement power over charities generally. So all of the land trusts, which are charities, have to potentially be subject to oversight by the Attorney General. The second would be whether a neighboring property owner perhaps has standing, even though the neighboring property owner does not have any part of, is not involved in the easement. And we did not intend to try to get into the law of that, which is very difficult and complex and which is not generally codified in the states, but just to leave that to other state law. As to validity, and the conference felt very strongly that perpetuity was a strong and necessary component of most easements, but we have to remember that in doing this, involving the statute, it's not only donated easements that are involved. We haven't addressed much about that today, but it's the acres of purchased easements in this country has gone up dramatically. I know in my own state of Maryland, where we've been accepting donated easements since the 70s, we now have more easements that have been purchased than have donated in acreage. We have 125,000 acres or 130,000 acres of donated easements, and we're now well over 300,000 acres of purchased easements. First in a farm program for farmland aimed at productive farmland, and secondly for others that are aimed at natural resources values rather than farming values. and also the extraction of penalties. You know, we have even courts now saying we hold a large easement in our Maryland Environmental Trust in our state that was a federal judge ordered the defendant who had done improper filling to grant an easement. It was over 1,000 acres, and so we're the holder of that easement. And of course, it's not donated. Some of the easements that are held by land trusts also are for a number of years rather than in perpetuity. There's nothing that requires easements to be in perpetuity as far as this statute is concerned. It permits easements to be in perpetuity or not in perpetuity. It's up to the donor and or the person selling the easement. And there are programs, the Conservation Reserve Program that requires it's a federal program with states' involvement, which are easements for 15 years. The problem of conveyance of these easements, at common law, you couldn't convey at a easement on property because that would be getting it away from that next door neighbor. So we had to make sure we had a provision about that. The Act also contains a provision saying it does not, it's not intended to affect the rules and laws that govern termination and modification. That those rules aren't intended to be affected. This is an act that is just aimed at getting rid of these restraints at old common law. And the comments, the act has a lot of prefatory notes and explanation notes. The rules of cypre and so forth are also mentioned. The interesting thing is, of course, since we wrote this was written at the end of the 1970s, right at the beginning of the charts that Nancy showed us, and I don't think any of us working on this had any idea that the number of acreage that Nancy was showing to us was going to happen. It's actually an incredible story of through largely volunteer action and through a unique legal rule, we have been able to save this many acres in this country. It's a tremendous tool. So the comments, since we wrote the act, some people would say, well, there's a place in here that says that in this act that you can, the manner of creation and termination of these easements is unchanged from other easements. And of course, the manner of doing it means the method of doing it, the way of doing it. And that's what the provision was intended to say. It does say that. And some people say, well, the manner, it means I can terminate it any time I want. So that's been an issue that we thought was very clear in the act, but perhaps not. So the amendment, the comments to the act have been amended to make it clear too what other bodies have said about conservation easements. And the American Law Institute, which has written something that writes regularly items of law called restatements of the law, and they're very influential in the courts. And two different restatements recently have recognized that easements are terminable only under the charitable trust criteria, which is, I think, really it's the criteria in the regulations as well. And so we included citations to both of those restatements and also to the Uniform Trust Act, which, as examples, cites also conservation easements. Every single kind of other charitable gift in this country is subject to the Charitable Trust Act, probably in every state in this country. And so conservation easements, if they were exempt from that, would be the only kind of charitable deduction that would not be covered. So with that, I'm going to conclude, and I hope I'll have a chance to discuss some of these questions with you later.